Good evening. This is Law's 11057 Introduction to Law. We're now into week 7 and we're dealing with a number of issues tonight. I'd like to start firstly with discussions in relation to the examination. And the exam format should be well and truly familiar to you. And that is essentially that we are dealing with an exam where there are 6 questions. You need to answer, 7 questions. You need to answer 6 of those. They'll each be worth 10 marks. So they're all of equal value. The exam is open book. And by that we mean really open book. You can take in any written material. You can't take anything which will allow you to access the internet. So that means no telephones, no devices of any type of that nature, no calculators. Not that you'll need that. But what that means is if you've accessed books electronically, if you've got e-books, then you won't be able to take those into the exam. I apologise in advance. I believe that there are 3 hours for the examination. The exam time has been set, and I trust that you've all had an opportunity to look at that. There's been some good discussions about the exam on UCrew, and it will be, as I understand it, Wednesday the 21st of October. That's at 9 a.m. for 3 hours. If anyone has information contrary to that, please let me know. And Hannah has put up a great link saying how you can find your exam schedule and where the exam can be conducted. So thank you for that, Hannah. Are there any questions about the exam logistics, the time, the place, how you set the exam, any of those sorts of questions? Feel free to unmute or come in through the chat facility. I'll put you on gallery view. We've got a few people there. No questions about the exam? All right. Well, we'll move on then. The exam requires you to answer the 6 questions. Now, you do know that there will be a question about separation of powers. One of the reasons that I'm mentioning this is that if you're going to answer that, I do expect to have a very high standard, something a little more than just the basics, something where you've thought about this issue critically and provide me with something that's quite interesting in that regard. So that's separation of powers. There's a question come through on the chat facility. Do we need to touch base with the local exam centre before we go in for the actual exam? I'm going to refer you back to the university, to the exam section. If people find a good link or they have a contact in the exam section, please let me know. I don't get involved in the logistics of exams, so that's all done centrally. And essentially what I do is I find out the date, and then the next thing I get the exams arrive at my desk. So I'm sorry I don't have a lot of information about that. So through UCrew or even tonight, if you have any information that will help your colleagues about the logistics of the exam, please let me know. Sorry, that was not exactly the answer you are after, but just being honest with you. Are there any questions at this stage? No? All right. The second thing is, there'll be, so separation of powers will be question number 1. So question number 2 will be a redrafting exercise. I'll warn you, it's a pretty tough one this year, and you'll need to practice that. Practice the technique of converting a whole mass of material into something in a number of condensed words. There is no minimum or maximum words count for the questions in the exam. If you want, you can spend all your time just on having a great answer to one question. Then, of course, the maximum you'll get will be 10 out of 60, so I wouldn't recommend that. So it's a matter of dividing your time generally pretty equally between the exam questions. I would put them in paragraphs, would be a good way to go. You can use sections, not sections, etc., says Tim. Yep. All right, so there's a few things that you might not want to worry too much about this year. And I should add, my comments are specifically for the standard exam. If you are one of the very few people that should happen to sit the deferred examination or supplementary examination, none of these comments apply. You'll have to, this only applies to the standard exam. Well, actually, I'll correct that. You can always bet on there being a separation of powers and redrafting. That will be on both. So, but the following comments apply only to the standard exam. Don't worry too much about the difference between legislation and common law, the difference between common law and equity. I mean, you'll see that in my past exams. By all means, study it, be ready for it, but I wouldn't worry too much about it. Don't worry too much about judicial activisms as such, although it's something you might want to touch upon in the context of separation of powers. I would certainly encourage you to think about some of the practical things that we've talked about and will talk about. I'm very keen for you to have your techniques in mind and ready to go. So think about how you will take instructions from a client and prepare basic proceedings, civil and criminal. So it's more the practical side, the process that you'll adopt. And have a clear mind of the process that you'll take, that you will have in mind for taking instructions from a client and appearing as an advocate in court for a client. A lot of practical issues there as well. All right, so self-management, we've talked about that a lot during the course. Well, I guess we have. I'm pretty keen for you to understand and be able to describe to me issues to do with your self-management skills and how you maintain proper equilibrium. Have in mind something about undertaking legal research, how you'll go about that. Being a critical legal thinker, that's important. What will you do to ensure that you are a critical legal thinker and an effective communicator? So I'm keen to know what techniques you will employ in that regard. Tonight we'll be talking about access to justice, administration of justice. I would pay close attention to that area of practice. And ethical obligations are really important, that you understand how to access information in terms of ethical obligations. And as indicated before, that's a great publication. The Australian Solicitors' Conduct Rules in Practice. That's available to be purchased through the Queensland Law Society. But it can be, the basics are able to be downloaded free of charge. And I think there's a link in Moodle in that regard. So that's all you need, just the free link. But if you want to go a bit further and purchase that copy from the Law Society, I think it's money well spent. And finally, I think, just generally resilience, which is a topic that we've talked about before. So hopefully that gives you some guidance as to what we want in the examination. Right, so let's talk about justice and commitment to justice. Firstly, in the context of criminal law, there are a number of issues that really immediately come to mind from my perspective. One is dealing with people that have limited ability to convey instructions or deal in a courtroom context, and we match that limited ability because it may be an intellectual disability, it might be a mental health issue, it might be issues to do with psychological issues. It may be just simple youth or age. There might be physical barriers. So there are a whole lot of issues in relation to criminal prosecution and people's inability to convey their case or argue their case convincingly. And if we match that up with limited funds available through legal aid, we have an ongoing and increasing problem where people find it difficult to actually obtain justice. And that's something that I'd like you to think about and have some solutions if possible. But it's very difficult to do. The duty lawyer service is stretched to the limit, And following the Moynihan reforms in 2010, many serious criminal law matters that previously had been dealt with in the higher courts, the District Court or the Supreme Court, are now being dealt with in the Magistrates Court, which means that there are more numbers of matters coming through the Magistrates Court, and they're becoming more serious in terms of the consequences and the nature of the offence. And it would be useful, I think, for you to look on the Legal Aid website and get an idea of what type of matters might attract legal aid funding for financially eligible applicants, and think about how that might have changed since 2010 with the Moynihan reforms. In essence, in the District and Supreme Court, provided you were financially eligible, you would get funding, and that funding would be for a solicitor and a barrister, and it would be funding for a plea of not guilty or a plea of guilty, whatever it might be. So, say for example, a burglary, a matter that previously could have or would have been dealt with in the District Court, is now generally dealt with in the Magistrates Court, so you don't get that automatic funding regime. Under legal aid guidelines, now the funding will only be available, generally speaking, for a solicitor, not a barrister as well, and only in circumstances where the person is at risk of going to jail. And then only for a plea of guilty. So you've got to ask yourself, how do we have a situation where there is justice being provided to those clients in those very tight financial constraints? Right, immigration law. There was an excellent series, I think it was on SBS previously, may have been repeated recently. Go back to where you came from. If you haven't seen it, I urge you to see it, and it will give you perhaps some really good insight into issues of immigration law, detention, and you might want to think about the issues to do with administration or provision of justice in those circumstances. There's a whole range of things. Legal aid also provide child protection cases. Yet there are a number of different areas where legal aid will provide funding. But in child protection, where you're acting for an adult, the parent, generally speaking, the initial funding is only for provision of advice and for reading the material and appearing on the initial mentions. Very difficult to get funding for a contested hearing in those circumstances. Human rights law, that's an excellent thing to consider about access to justice. And how do people with mental health issues, for example, obtain some sort of justice to deal with not only criminal law prosecutions, but also civil law matters? Think about issues to do with guardianship and administration, which is something that I do hear matters in QCAT. So that's where a person who may lack capacity to make decisions can be the subject of a guardianship or administration application in that particular tribunal, QCAT. Child protection law, we've talked about that briefly. That's an area that might be worth looking at. Domestic violence, can people who are involved in domestic violence situations obtain justice? So I'm really providing you with headings that will allow you to undertake a bit of extra research and think about how people in these situations do or do not have access to justice, is really the point of the exercise that we're talking about. Environmental law. Look, environmental law is really interesting. I do take these subjects at the university as well. And if something is proceeding which has a great financial interest for the proponent, the question, I guess, is how do the general public obtain or have access to justice in those circumstances? So you might want to think about access to justice in the context of environmental law. And one of the things that you must always consider is a concept called standing. Standing is really that area of law that means you are entitled to bring this action before the court and be heard. Just to take an example of standing, which is relevant in the context of, say, environmental law, if I was to go to court and argue that a third person should have a remedy against a fourth person, the court might rightly say, well, that may well be the case, Mr. Milburn, but what have you got to do with it? You don't have any standing, this is not your case, so why are you here? So if you're an individual in Brisbane concerned about something that might be happening in Tasmania, the question is, as an individual, how do you go to court? Do you have the right to go to court? Do you have standing? Are you able to say, this is an environmental issue of concern, I wish to be heard in relation to the matter? So maybe just doing a bit of basic research in that regard would be worthwhile. Family law is always an issue. One of the matters that have changed in family law in the context of administration of justice or access to justice is now, in order to prosecute a matter involving children, there is a prerequisite, and that is that the parties attend a mediation session and obtain a certificate to essentially authorise them to go to the Federal Circuit Court or the Family Court if they wish to prosecute a matter involving having contact with or childing regarding a child. So that might be a good thing or it might be a bad thing, but I'm really keen for you to think about that. Other issues, personal injuries law or anti-discrimination, there might be some issues that arise from that which deal with the question of access to judgment. All right, some comments here about recent mining and the Greens issue about who can stand. Yeah, there's been a lot of interesting case law about that. In Queensland, we have the situation where the current government is seeking to reintroduce the ability for certain parties to challenge through the land court certain decisions which are referred to the land court, and that follows on from a case of BHP against Isdale. That's worth having a look at, BHP and Isdale. It created some interesting comments. Actually prepared a paper on that. I might upload it. I'll make a note to myself to do that. And that has some interesting comments about, I suppose, standing generally and access to justice in the context of environmental law. At a federal level, at the same time, the attorney has indicated that he does want to restrict access in certain circumstances. So we have a different approach being adopted in relation to very similar issues at a state and federal level. So paper re-environmental law. Okay, I'll upload that. All right, so there's a few things coming through on the chat facility. What happens in matters if mediation, one of the parents is not able to be located for various reasons or they don't show? And the response, thanks to Mara, they have 6 weeks. If they haven't found the other party, then they will be issued a certificate and then the proceedings can commence. Thank you very much. So that's just following on from that point that I made about, access to justice. People aren't automatically entitled to go to the Family Court or Federal Circuit Court and argue their case. They need to go through a procedure first, which involves mediation. And if the other side can't be caught up, then thanks to Mara, 6 weeks. If the other party can't be found, then the ADR practitioner will provide a certificate to enable proceedings to start. I hope you followed all that. We're moving pretty quickly tonight. I appreciate that. And hopefully you're following what I'm saying. Are there any questions? Anyone wish to come in with a question? I've just got you on gallery view now. All right. Okay, so the point of tonight's exercise is to think about what's involved in accessing justice through the court or other system. Now, there are some other issues, and legal aid will want to try mediation as well in relation to family law. Let's talk about procedural justice. There is a basic rule, and that is that parties who attended court have the right to a fair hearing. Natural justice means that a person has an opportunity to present his or her case and be heard and not be shut down, but they need to be given that chance to be heard. So that's natural justice. You might want to think about that, do a bit of basic research on it. There is a rule in criminal law which is called the rule in Brown against Dunn, Brown and Dunn. That's B-R-O-W-N, v. Dunn, D-U-N-N-E. And it's a rule about being given a chance to test the evidence of the opponents through cross-examination. So you might want to have a look at the rule in Brown and Dunn. It's a fairly specialised rule, but it is an important rule if you're practising in criminal law. Now, speaking of criminal law, in terms of access to justice, you might want to think about the right to refuse questions which might incriminate. Is that a good thing or is that a bad thing? So, generally speaking, a person is under no obligation to answer any questions when called upon by police to do so, other than name, address, date of birth. So if a police officer says, "Did you steal that item?" you're entitled to remain mute and not provide an answer or response to that. So that's your right against self-incrimination. So is that a good thing? There are some exceptions to that. ASIO and through the Crime and Corruption Commission, you may find that people are required or compelled to not only attend, but also compelled to answer questions, even if the answer to those questions may incriminate. So is that fair? Think about the issues involved in that. Are we considering the greater good in that context? Are there safeguards that can be put in place or should be put in place? The next thing in terms of access to justice is considering the burden of proof on the party to bring the action, which is also known as the onus of proof. Again, I know I'm moving around a bit here, but when a party brings an action, as far as the other side is concerned, the respondent or the defendant, I guess the question needs to be asked, who has to prove this case? And the general rule is that if you're going to bring the case, you have to prove the case. But the extent to which you prove that case will differ depending on whether it's a criminal law matter or a civil matter. Now, can anyone tell me what the burden of proof is for a criminal case? Assuming that prosecution have to prove the case, to what extent? Millie says beyond reasonable doubt. Thank you. That's it. So in a criminal case, the standard of proof, the extent to which the proof has to be made, is beyond reasonable doubt. Can anyone tell me, thanks Ash, and what's the standard in a civil case? What's the general standard in a civil case? Ash, balance of probabilities, thanks Justice, that's it. So 50-50 as opposed to beyond all reasonable doubt. In terms of the administration of justice, is that a good thing? Is that a fair thing? Should that be changed? What are your thoughts in that regard? Okay, let's talk about the difference between retributive justice and restorative justice. And you've seen some notes on this in your text. So when one is talking about retribution or retributive justice, we're really concerned about how best to punish a person. Restorative justice is concerned with restoring the situation, perhaps healing the victim, and contrasting that, reintegrating the offender into the community. So give some thought to that distinction. Also give some thought to what is the best way to proceed. And think about, in the context of access to justice, does that change from person to person? For example, should there be different rules that apply in a criminal law context to defendants who are children, or defendants who have mental health issues, or defendants who perhaps are aged? Should there be a greater emphasis on issues to do with retribution or restoration in those circumstances? I appreciate, I'm not providing you with many answers tonight. I'm really providing you with a list of headings that you might want to consider in the context of your own study, your own research, and bearing in mind that I gave a little hint at the start of tonight that issues to do with the administration of justice and access to justice is really quite important. And if I ask you an essay-style question about the administration of justice or access to justice, you've got a huge array of things that you might want to consider talking about. The exam doesn't require you to just list them all out. I'm really looking for some creative thinking. So I don't think you have to cover every point when it comes to an exam question. I'm really looking for some insightful answers, even if it means that you're narrowing in on one area. That's fine. I actually prefer that rather than just a broad list of dot points, because you know I don't like dot points. So I hope that's providing you with some indication as to the way in which I'd like you to approach this area of study. Okay, no questions at this stage. I'll move on. Then there's a question of access to justice. So I've briefly talked about legal aid funding, the difficulties associated with getting legal aid funding. Do some research in that regard. Go on the website. It doesn't have to be just Queensland. You can look in your area if you're in a jurisdiction other than Queensland, and you can provide your response dealing with the area of interest for you or the geographical area for you. Think about the question of access to justice and the concept of lawyer-free jurisdictions. Is that a good thing or a bad thing? And what do I mean by lawyer-free jurisdictions? Can anyone give me an example of where lawyers' involvement is either discouraged or indeed prohibited, or perhaps prohibited unless there's consent? QCAT, yep. Mediation. Thank you for those responses. Now, just when on the topic of QCAT, be a little careful, because there are really two broad areas. Well, there's a few different broad areas. In QCAT, we have the area of minor civil disputes, which is the old small claims tribunal, which is wrapped in. But QCAT's a whole lot more than that. And there are many areas of QCAT where, for example, we've talked about building disputes, domestic building disputes, where the jurisdictional limit is unlimited. There is no limit. So you can have potentially a $2 million claim going through QCAT. And there are other, in the human rights jurisdiction of QCAT, say guardianship and administration, we've talked about that. Usually members will allow legal representation in that jurisdiction. So don't think that QCAT has a blanket rule, no lawyers allowed. Lawyers appear in the QCAT jurisdiction very regularly, but the type of dispute being dealt with will have a major bearing on that decision. Mediation, many mediators, and I'm a nationally qualified mediator, many mediators will not allow lawyers in certain circumstances. My personal preference, I like to have lawyers involved in mediations. Other areas where it's lawyer-free community conferencing, says Diane, residential tenancy authorities as well. So think about some of the circumstances where lawyers are not allowed or they're discouraged, and think about, is that a good thing or a bad thing? Think about maybe the pros and cons. And if a party is either forced to represent themselves as a result of legislation or perhaps forced into it through financial constraints, think about some of the issues to do with access to justice in that context. There might be some issues like literacy or language, multiculturalism. Think about the type of jurisdiction as well. Is it an adversarial jurisdiction or an inquisitorial jurisdiction? Do we know the difference between those two? I think we talked about that before. Adversarial, one against the other. Inquisitorial, where the court or the tribunal takes an active role in trying to discover the situation, as opposed to being essentially on the sidelines and letting the parties argue the case, which is more the adversarial role. Okay, so there are some challenges associated with access to justice for a party involved in self-representation. I guess an obvious one is people have to have access to and understand the law. And if you don't have a lawyer representing you, you're not allowed to have a lawyer representing you. Is that a fair thing if people can't access the law or they can't understand the law? And then, of course, there's the whole issue of familiarity with process. And I just ask myself this question. If we have a situation where lawyers are not allowed to be involved, does that create a situation where many, many cases are not heard because the people involved are overwhelmed by the thought of the process? They don't understand the process. They don't understand what it's like in a court. They're not game to walk into a courtroom, and they feel helpless, isolated, unable to proceed, and cave in because they say, I couldn't possibly go into a courtroom. I'm terrible at public speaking. I couldn't possibly run a case for myself. I might as well drop the claim, or I might as well concede to the other side. So do lawyer-free zones actually serve a positive purpose or a negative purpose? I'm trying to make this very neutral. And why do parliaments introduce lawyer-free zones? What is the public policy consideration behind that? Is it a good thing? Does it work? Does it not work? So think about that. Maybe think about some examples of legislation where there is a specific provision in the legislation to say lawyers are not allowed in this context, in this courtroom. Okay, maybe think about some alternatives. When could it work? Diane says that lawyer-free zones often have professional advocates assisting, and I guess they do. Maybe it helps to bridge the gap between the general community and the courtroom, says Melly. So thank you for those comments. Think about the issue of cost. If you don't have lawyer-free zones, then contrast that to a situation where people feel that they can't afford a lawyer, the other side's got a lawyer, and they're going to be overwhelmed by that as well. Can I suggest a good website for some discussion on lawyer-free zones? Yeah, there might be, on the QCAT website, there might be some comments about self-representation. I think QPILCH, Queensland Public Information Legal Clearinghouse, QPILCH, QPILCH, that would be worth having a look at as well. There might be some website, Legal Aid Queensland, might be a good place to go. Local courts, Welfare Rights, says Rebecca, they're all good websites. So some really good ideas there, thank you. So do some thinking, creative thinking about access to justice. Where it applies, is it a good thing, is it not a good thing? Okay, we're getting close to the end. Thank you for your patience. Again, I appreciate I've been doing a lot of talking. Discrimination, disadvantage, injustice is my next heading. So the cost of legal proceedings and the deterrence of cost is an issue. You know, coming back to that issue of, say, environmental law, if a person says, I'm going to challenge this mine, or I'm going to challenge this proposal to have a dam built, first thing you've got to overcome that issue of standing. But let's say the court says, yes, I'll welcome you in. You can litigate this matter. What happens if you lose and it's a big case? The other side may say, well, they brought us to court, they lost, therefore they should pay our costs. Here's a bill for $100,000. You know, is that fair? Look at it from the perspective of both the mining company or the government wishing to introduce a dam, and look at it from the perspective of the person who challenged the issue in the first place. So there are a few different aspects that need to be considered there and balanced up. Think about prosecutions and perhaps this point. Is it fair to say that it's easier to prosecute low-end offences and therefore they are more often prosecuted than high-end offences? By that I mean this. One would imagine it's easier to prosecute someone who is charged with public nuisance. They're there on the spot, it's easy to prove, as opposed to prosecuting someone for a very complex scheme which is conducted through the internet, which is very technical in nature. Now, one may have much greater ramifications, but it may not be prosecuted because it's too hard. Now, is that fair? Is that providing justice? Is that the way it should be? I'm not suggesting that is the way it is, but just posing the question. I'd ask the question about mandatory sentencing. Is that a good thing in terms of administration of justice? Is that a bad thing for administration of justice? Are there arguments both ways? If the government says, if you commit this offence, then you must suffer a penalty of this as a minimum, is that a good thing or not? So, for example, the government introduced the Section 754. We did some research on that on UCRU, and imposed a penalty. If you fail to stop, then you must suffer 50 days imprisonment, of actual time imprisonment, or a minimum fine of $5,500. Is that a good thing? Does that create certainty? Does that deter? Is that a bad thing? Does it take away the ability for a court to deal with individual circumstances? What if a person with marginal mental health is caught up in that system and ends up in jail because they just didn't understand what was expected of them? All right, so mandatory sentencing in the context of administration of justice, or access to justice, if you like, is an important concept as well. Okay, the last topic that I want to talk about briefly in terms of access to justice and administration of justice is alternative dispute resolution. And we've touched on briefly mediation is one option, but there's a whole lot more to ADR than just mediation. Does anyone know any other techniques or platforms that can be used which are generally called alternative dispute resolution? Mediation is one, it's probably the most well known. Conciliation, thank you, Justice. Conciliation is like mediation, but the conciliator has a more direct role, and the conciliator is often an expert in the field and will actually provide some advice carefully and generate options, where in its pure form, mediation is designed to be non-interventionalist. Arbitration, thank you very much. That's another important form of ADR. That's the closest one that, to court proceedings. Arbitration is where the arbitrator hears a case, much like a court would hear a case, and instead of making a judgment, the arbitrator will make an award, but it has legally binding effect. Negotiation, right, so that's at the very other end of the scale, and that's where essentially the parties are trying to resolve the agreement themselves, generally speaking without the involvement of a third party. So that's a very that's a form of ADR which is very much allowing the parties to generate their own way of resolving things. Okay, so apart from that, we have lots of different things. I'll just mention a few: collaborative law, expert determination, mini-trial, referencing, adjudication, mini-trial, thank you, Rebecca. So there are a whole lot of different ways. I just ask, I don't want you to study that in detail by any means. If you do my alternative dispute resolution course, then we'll do lots of those things. That's 12062. But just think about that in the context of administration of justice, access to justice. Should we be using ADR more extensively, and if so, on what basis? Okay, well, that's all that I propose to talk about tonight. I think the reading for tonight was chapter 12 of the text. Are there any questions about what we've discussed? Are there any questions about the reading? I will upload some material in relation to ADR and environmental law, which might be of interest to you. And there's some discussion there about BHP and Esdale, a recent case. Okay, well, thank you very much for your attention. I'll stop recording now.